Hi, everyone. We're just giving it a few minutes just to see who else will be joining us. Let's go ahead and get started. Okay. All right. So, welcome to PantherlabWorks Entrepreneurial Realities and Legalities series with GTC Law Group, embracing AI while avoiding legal minefields, managing complex legal risks in an AI-first world. My name is Elena DeHoratius, and I am a technical consultant with PLW. We are excited that you're here to learn from our exclusive legal sponsor, GTC Law Group. Their continued support allows us to be able to provide programming and no-cost consulting services to technology and manufacturing companies. GTC is a fantastic partner of PLW, as GTC is ranked #1 in patent quality, has advised on hundreds of M&A transactions, has an industry-leading open source software practice, and represents the world's best-known technology companies. GTC's team spans artificial intelligence, privacy, data protection, and more. So a few housekeeping items today. Please put your questions in the Q&A or chat. We will be addressing them at the end of the session. In addition, if you are using a username that differs from your registration name, please put it in the chat so that we can count you as attended and provide the additional resources to you. Without further ado, I'd like to welcome our speakers today who will be introducing themselves.
Thank you, Elena. Thank you all for tuning in. My name is Tony Decicco, and I work in the artificial intelligence, open source software, and patent strategy and portfolio development groups at GTC, a tech boutique law firm. We've been fortunate to, on the one hand, represent several large Fortune 500 serial acquirers in the software and hardware space, as well as VCs and PE firms. And on the other hand, we represent many startups and mid-sized companies. So along the way, we've gained insight into the practices of hundreds of organizations, including many creating and leveraging AI and ML. So overall, we're well positioned to understand the points we'll talk about today from all sides of the table. My practice focuses on AI, open source, patent strategy, and IP transactions. And my first exposure to AI was probably a dozen or more years ago, helping clients license data sets for training ML models, doing some derivative works analyses on the resulting models to see if they're derivative of the data, and then obtaining related patent protection. And I've just been active in the area ever since.
And I'm Stas Zakharenko. I joined GTC after almost 20 years in-house, including at Amazon, Audible, and Netflix. At Audible, I eventually ran the legal department as general counsel. And at Netflix, I was one of the first attorneys dedicated full-time to their AI issues starting around 2021, where I was embedded and worked closely with their data science and engineering teams. And at GTC, I co-lead the AI practice group together with Tony, and we've been advising companies on AI governance, including policies relating to adoption of AI tools, development of AI coding assistance, and negotiating agreements in the procurement of AI technology. Here's how we've organized this next hour. We can think of it as a tour through all the ways that AI can create legal exposure and what you can do about it as you're starting up businesses. First, we'll touch on IP ownership, who actually owns what AI creates, what can you do to protect it. Infringement, where your business could end up on the wrong side of a lawsuit. Regulatory compliance, product liability, disclosure as to what you may have to tell the public or regulators about your AI, and finally, some practical governance steps. What can you do to mitigate some of these risks in your business? So what's at stake in your business when it comes to AI? I think before we get to the details, it's good to ground ourselves and why it matters. The tendency in the startup world tends to be you just build stuff, and then when you go raise your Series B, you try to sort it out at that point. But looking at history and the early days of the internet, you can tell how that may be an approach, but that may not be necessarily the right approach for everyone. So looking at the early lessons, there was a company in the early music streaming space called Napster that had millions of users, genuine good product fit. Everybody loved it, but of course it wasn't licensed. And it didn't last very long after a lawsuit an injunction was obtained and it couldn't comply with it, and it essentially the product as it existed then quickly went out of business and no longer exists. A similar business under a similar premise of putting content out there that wasn't licensed was YouTube. And of course, they had a very different outcome. They put it forward. There was a $1 billion lawsuit against them, but eventually they implemented a system called Content ID that allowed some of this content to be monetized by the license holders, and it survived. So started with a similar premise, but did make it. We're seeing a similar divide today. Some companies are launching AI businesses on licensed content, like Adobe, for example. They launched an AI image generated on licensed content, and other companies, including all the major LLM providers, are taking greater risks, trying to see is what they're doing fair use, taking it all the way through litigation. And so as you're thinking about your businesses, these are all the things that need to be approached intentionally and mindfully, right? There's not necessarily one approach that works and others that won't. We'll see 10 years from now where we are, but knowing where you stand is very important. So we'll look at things like lawsuits. There's now over 300 cases active, where 4 years ago there were none. Regulatory fines, where can things come at you from regulators depending on what you do? What happens with your intellectual property, both in terms of existing and future, as you're creating things with AI that may not be protected? What does that mean for your business? And reputational damage. When you're using AI to power whatever product you launch, at the end of the day, your product is the one that's associated with the good and the bad that's going to be out there, not necessarily the model that's powering it. So if the model fails you and your product does something that causes you to be in the news in a bad way, it's going to be potentially your brand associated with it. So with all that said, I'm going to turn it over to Tony for the next section.
Great, thanks, Stas. So AI can be used to generate text, images, video, music, computer code, and even data, such as synthetic training data to train additional AI models. One of the questions I get most frequently is, who owns the output from the AI tools? So, if we used AI to build this, the code, the design, the marketing copy, who owns it? And can we stop competitors from copying it, from using it? And the answer depends on which type of IP you're talking about. Across copyright, patent, trademarks, and trade secret, each handle AI a little differently. And we'll go through each of them in turn. Let's see if I got control of the slides. All right. So we're first talking about copyright. Copyright's the most immediately relevant for most of you because it covers, written content, images, and code. The current U.S. position is only human authorship is protected by copyright. So author in the Copyright Act is interpreted to mean a human being. So this means, content generated entirely by AI can't be copyrighted. So a work created entirely by a machine is not copyrightable. But human contributions around or within AI output can be copyrightable. So, a larger work that incorporates AI-generated material, can be protected for the human authored parts. So here's an example from an actual case. A graphic novel where the text and the overall narrative are human written, but the particular illustrations are generated by AI. You can claim copyright in the text, just not the images. So what does all this mean in practice? If there's content you must own, such as key computer code or text, don't use AI tools to create that content. If there's content where the ownership is nice to have, then it may be worth it, take additional steps to try to document the creation process, their prompt strategy, selecting the outputs, editing the results, and for everything else, have at it with AI. There's also a flip side issue around copyright. It's possible that the AI outputs themselves may infringe someone else's copyright. GI tools have been known to produce outputs, likely those contained in their training data that include content that may be copyrighted by others, like images, song lyrics, other text, and computer code. So an example we'll talk about later, generative AI coding tools often generate snippets that match the code verbatim included in the training set, like open source software that it was trained on, and that can be under license terms that aren't commercially friendly. So it's important to have a process to vet the output, code scanning tools, Google image searches, and have guidelines, to not prompt the AI tools in a way that makes it more likely that the outputs will be infringing. And then turning to patent protection, the current U.S. position is only human beings can be inventors on a U.S. patent. So an inventor must be a natural person. An AI system itself can't be named as an inventor. Invention developed with assistance of AI can be patented, though, as long as there's at least one qualifying human inventor who made a significant contribution to the claimed invention. We had some revised guidance in 2025 that, basically stated the same inventorship standard applies to all inventions. There's no special standard for AI. So in practice, this means if AI contributes to an invention, you have to have at least one human to have contributed in a way that meets the normal threshold for inventorship. They conceived of key elements of the claims, and then only those humans are named as inventors. So where humans use an AI tool, to explore a design space, generate options, run simulations, that's fine. The humans then have to identify, refine, claim the inventive concept. The resulting invention can still be patented with those humans, named as inventors. So why does this matter for your startup? If your engineers, your developers, your data scientists are using AI tools heavily in their development process, and you want to patent the results, you need to be able to point to which humans made the inventive contributions. You can't just say like the AI came up with it. Like that's not going to work. So it's good to document the human contributions if your R&D process is AI assisted. We'll turn next to trademarks. So, trademarks are interesting since they actually cut the other way. Using an AI tool to come up with a name or logo usually doesn't prevent you from owning the trademark in the United States. This is because trademark rights are based on use in commerce and control over the quality of the goods and services, not on who created the design or the mark. So you still have to check the output. It's possible that the logo or mark or one similar to it that the AI generated is already in use and owned by someone else. So trademark clearance is just as important, if not more important here. And most AI providers that do indemnify you and cover you in their contract do it for copyright. They don't typically indemnify for trademark infringement. There's also an interesting intersection with the copyright that we talked about before. A logo created entirely by AI might be protectable as a trademark, but it might not qualify for copyright protection, unless there's sufficient human creative contribution, like editing it, customizing it. So it means you could own and enforce the logo as a trademark in your branding context, but you probably will have, weaker tools to stop like non-branding uses that were to be based on copyright. And then the last area I'll hit is trade secrets. So under current US law, there's no human creator requirement for trade secrets. So information generated by AI can qualify as a trade secret if it meets the usual criteria. It has to have independent economic value from not being generally known, and you have to put in place, reasonable measures to keep it secret. And that last part is probably the most difficult when using AI tools. Trade secrets are probably the most immediately practical IP issue for most of the companies here. The risk is happening right now across almost every startup. So here's a scenario. One of your engineers is trying to, debug a tricky piece of code. They paste the relevant code along with some internal architecture context into, let's say, the free public version of ChatGPT to get some help. Or someone on your team summarizes a confidential business strategy in the free public version of Claude to help draft a memo. So in both cases, they may have just destroyed your legal and trade secret protection over that info, since you need to take reasonable measures to keep it secret. So putting it into the public AI tool and allowing a tool, that can use the inputs for training, and could result in the disclosure to others, can eliminate that protection. So, that's the reason most corporate AI policies ban the use of like consumer AI tools, at least for use with confidential information, and they favor the use of commercial, enterprise grade tools where the vendor agrees to confidentiality obligations. They agree not to use the customer data for training, so those wouldn't pose the same sort of risk from a trade secret point of view. So I'm going to hand it back to Stas to talk about infringement.
Great, thanks, Tony. So we'll touch on two main areas of infringement where AI creates risks, and that's in the training phase. What are you using to train the models, or what are the models you're using? What have they used to train themselves? And what are the outputs of those models, both in terms of what the models can produce and how are you using them, and where liability comes in. So first, model training. This is where most of the litigation today exists around AI training data. And typically, the claims are that whatever data was ingested for the process of training the models, both the collection of the data and the use of that data constitutes copyright infringement. And it'll take still probably a decade to fully resolve all these cases between the initial cases that are going on and all the cases of appeal. But it's worth touching on two specific ones. One was Bart's versus Anthropic, and that was a case by book publishers against Anthropic. And the court actually ruled that it was fair use to train the models using text if the text itself was legally acquired. So for books that the physical books that Anthropic got and scanned and used those to train the models, the court said that's fair use. However, Anthropic also scraped pirated databases of books that it didn't have permission to get. And the court in that case said that that process and creating a library of those scraped books for purposes of training the model was itself infringement, and ultimately Anthropic settled the case and agreed to pay around $1.5 billion for those pirated libraries. And then there was a case that reached a different conclusion, but also under very different facts. Thomson Reuters has a tool called Westlaw that a lot of lawyers use. Human editors create summaries of cases for each case that are called head notes. And a different company, Ross Intelligence, was trying to build a new product using AI that had similar functionality, and actually had hired humans, lawyers, to create memos based on those Westlaw head notes. And in that case, the court said that was not fair use. And that case is currently still under appeal and is very much very, very active. So it kind of shows the key takeaway that there is no one clear answer as to whether training the model with copyrighted content is or is not fair use, that it is really fact dependent. And you don't really know whether you have fair use or not until you go through the court case, the appeals, and everything like that. So if you're building or using a product in a way that's using copyrighted content and you hear the term fair use, that's one thing to keep in mind, that there isn't really a bright line. It is fact dependent, and oftentimes, even if you think where you'll end up, you need ultimately a judge to tell you where you are. Another way that content gets into the training models is scraping. And sometimes kind of it can feel like, hey, there's a lot of content out there and I can just grab it. But there's been a lot of litigation in this space as well. And that litigation centers around claims of Computer Fraud and Abuse Act and also contractual terms, the terms of use. So when a scraping tool goes out and gets that content, if it's just purely out there and it doesn't involve assenting to any terms of use or bypassing any content protection, generally that's deemed okay if you're honoring things like looking at the robot text files and honoring them. However, if you have to create an account or you have to click something that says I agree, you're probably consenting to terms of use that say you're not allowed to scrape my website, you're not allowed to take my content. And if you're having to go through measures to bypass protections that have been put in place to prevent your scraping, there can be claims under the Computer Fraud and Abuse Act. And SERP API is one popular company right now that's facing these claims. And their users like Perplexity are as well. And so that's an active litigation that many are looking at right now to see if some of these counter scraping measures are enough to create a claim when a scraper is bypassing them. Model output. So that's the flip side of the equation. And that looks at, okay, is the stuff coming out of your model itself infringing? There's fewer claims in this space because a lot of the main heavily used tools kind of got ahead of that issue and have filters in place that attempt to prevent the output from looking like the input and avoiding some of these claims. But they do exist. And so, for example, Getty Images was sued by Stability AI. Getty Images sued Stability AI in both UK and the US. And ultimately, the court in the UK ruled that outputs reproducing Getty's watermarks infringed its trademarks, touching on something that Tony spoke before. And in that case, actually held that Stability, as the model provider, not its end users, would be responsible. The U.S. case is still ongoing, so we'll see where that ends up. In the music space, the AI companies generating music like Suno and Udio have also been sued by the labels. Those did not ultimately go through the court process, but the claims were very much based on the output that those tools produced. They're being sued, but have also now entered into licensing deals. So Universal Music settled with Udio, and Warner and Suno have also had settlements as well. So it kind of shows that these claims are strong enough that the providers are choosing to settle versus taking them all the way through litigation. And then as a user, there was a case with Tesla, which is also still ongoing. Tesla was asked for and was denied permission to use scenes from Blade Runner 2049 and its 2024 Cybercab product launch. Then allegedly it fed the films into AI tools and had AI generate similar imagery itself, and Alcan Entertainment sued them for copyright infringement. And I think the latest news, as of maybe actually as recently as last week, shows that they're trying to assert First Amendment defenses, et cetera. So we'll see where that ends up. And finally, right of publicity. There have been claims against voiceovers that are sound-alikes of famous people. Those have also kind of been settled, but that's another area that you need to watch out for if you're using AI to generate voices that are supposed to sound like a celebrity or recognizable person, even mildly so. That could lead to claims under both existing right of publicity laws, which are state-specific, and newly enacted laws specifically targeted to this issue, like the Tennessee Elvis Act, which covers AI voice clones. Moving on to the next section, which is regulatory compliance. This is an interesting one, as there's always talk of new AI regulation, but the fact is a lot of the current regulation applies and it creates equal, if not more, risk under AI. Currently, there is no single US federal AI law. And in fact, the current administration has tried to block or weaken some of the state efforts. However, that's not been successful. And so far, existing laws that are out there on the state level, and there's about 38 states that have enacted various AI measures, sector-specific regulation in regulated industries, and also existing federal law still very much applies to use of AI. So we'll cover some of that briefly. First is discrimination laws. If you're talking about a product that touches employment decisions, whether it's hiring, screening, scheduling, performance evaluations, lending, credit decisions, things like that, the developers and users will ultimately may be subject to discrimination by what the AI tool does, and the regulators are actively looking at those issues. And the guidance is clear. If you couldn't discriminate under before AI, you also now can't discriminate when you're using AI, and the fact that you're using AI is not an excuse. So you need to look at what is the AI tool doing, and sometimes that's hard because it's often a black box. So if you have an AI tool that is involved in some of these things, you need to have bias audits and have someone test the tool, figure out are its outputs, are its decisions discriminating against certain protected groups, and then adjust the tool accordingly. And in fact, laws like the New York City law number 144 requires you to publish these reports. That law's been in the books for a couple of years, and enforcement's been slow going, but there's indication that enforcement may increase in the near future. Similar rules apply in the fair lending space, in the insurance space, in healthcare, and in housing. So just to sort of summarize, you really need to know if you're in those spaces that you're going to have a closer lens on you than if you're in a different space, maybe that's purely entertainment or informational. Privacy is another area that is heavily regulated, of course. And privacy and AI really intersect at every point in the product. It's not just what you're training the model with, but every time the product collects, processes, or routes personal information, including information that comes in as inputs, privacy rights are likely implicated. The major providers, if let's say you're built a tool using one of the large LLM models, and companies like OpenAI, Google, Anthropic, and Microsoft all offer data processing agreements that outline the terms under which they will process and protect personal information and what they will do to comply with privacy laws like deletion and et cetera. But the challenge is not just having that agreement in place, but you really need to map out what happens with that data, where does it go throughout the entire flow, and know where you stand in terms of compliance. If you're collecting images or videos or other kind of biometric information, there are extra laws that apply to those modes of collection, and they carry heavier fines. Particularly Illinois, the Biometric Information Privacy Act, the statutory damages can be $1,000 to $5,000 per violation. And oftentimes, even just the act of collecting videos outside of the entertainment context will put you in the crosshairs of that law. So very important to know. And then, of course, if you're using AI vendors, you need to understand what they're going to do with the personal data you're providing them, particularly if they're not one of the large ones that I've mentioned and you don't have a data protection agreement in place. Another part of privacy laws is typically automated decision making. These are laws not typically specifically targeted towards AI, but are now becoming increasingly relevant for AI. So, automated decision-making regulations typically cover the rules, typically cover situations when a machine is making decisions about people. And that could be programmatic rules or it could be AI-generated rules. So if the system is deciding who's getting a loan, who's getting hired, who is maybe getting a parole in a criminal setting, those laws typically say you have to be able to explain why the system has made the decision, appeal to a human review if you don't think it's right, et cetera. And that topic's dealt with both by the European Union AI Act, which is the most famous and comprehensive AI regulation that exists today. But it's also increasingly enforced at state levels, including in California and other places. So a human in the loop in those kinds of systems is still essential. You have to understand how your system is making these decisions and then have basically a bypass valve if there's an objection to what the system is deciding. And then finally, product and performance liability. Like where could your company have liability based on what your product's actually doing? And that could come both for outputs, if you're just providing text or other types of information for people to act on, or if your system is agentic, meaning it's actually performing the actions, where can liability come from the actions themselves? And that the latter one is the kind of most current and most interesting space. So let's start with the most familiar example, I think, that we've maybe all seen in the headlines today, which is information that an AI system is giving you. So OpenAI and other companies have been under scrutiny for providing information on self-harm. Somebody asks an AI chatbot, what can I do to harm myself? And it's actually doesn't have the proper safeguards in place to not provide that information and encourages a person, particularly a minor, to do something bad. So that's been one area of liability that's very active, ongoing, and companies are defending and actively settling these lawsuits. And other areas that you could see is product liability if you're building an AI towards a particular professional space, and they're subject to rules. So, for example, lawyers are subject to rules that say they have to be honest and provide competent services. If your tool is making representation that, yeah, it's going to 100% give, generate 100% accurate briefs to file in court, and then those briefs have like false citations, you might be liable for the representations that you made as to the quality and capability of your product. That, of course, goes even more so if it's in the medical space or other space where people's lives are at stake. And putting out just simple disclaimers that, hey, this thing may be broken, may not necessarily save you if you're not putting the right measures in place to actually be responsible. Just having a disclaimer doesn't protect you if you're negligent in designing the way your product works. This is also a reminder of what I said before, which is if your product is the one that has caused the damage, it'll be your product in the news, probably not the model that you're using in the background, and you won't necessarily be able to blame them. One sort of side point on this is keep in mind your insurance, because modern insurance policies are increasingly starting to carve out liability caused by AI, and your insurance may not cover you for the damage that your AI-enabled product causes unless you buy a specific endorsement, or it just may not cover it at all. Moving on to agentic AI, and hopefully everyone on this call at this point knows what it is, but just quickly, as short summaries, agentic AI is not just generating answers, but actually you give it a plan of what you need to achieve, and it can pick the tasks that it's going to perform to achieve that plan. It might actually pick different AI models to use. It will take action on your behalf, and it will continue operating until it achieves its purpose, its agentic purpose. And this is where the questions get really interesting, because if that AI goes out, you gave it a task, it goes out to do certain things, and in the process of doing that, it creates some sort of liability. Who is responsible for that? For the action that it performs, when it causes harm. So that's still very much an unsettled question, but there is existing law that we can look to guess where things are going to potentially lead. You can look at existing agency law. So same thing with humans. If you ask the human agent to go do something for you, and that human does something that you've directed it to do, you could still be liable. Potentially the same things could carry over to when that agent's no longer a human, but an AI system. And of course, what happens if that agent goes out and does something that legally binds you to an obligation? Maybe it goes out and signs a contract for a big purchase on your behalf. Maybe to achieve your purpose, it signs up for a subscription for the next 3 years that'll cost you $50,000, right? Are you liable for what that agent did or not? And I think the answer is like, yes, potentially. So what does that all mean for you? If you're using those agentic systems, you need to understand their capabilities. You need to fence them in terms of what you're allowing it to do, what kind of credentials you're giving them, what systems access you're giving them, and of course then monitor and have the ability to pull the plug if they're going off the rails. And so if you're building agentic AI into a product you're building, that's very important to get the appropriate level of engineering, security, and legal review as to what it's doing. And then finally on disclosure. So there are increasing regulations on what you have to tell the public when you're using AI, and are you deceiving consumers as to what you're telling people about your capabilities, whether or not you have AI, whether or not you have agentic AI in your product, and then do people using your product understand and know that they're interacting with AI? And there's laws covering all of those topics. There's been enforcement against companies for AI washing, who have said like, hey, my product has this great AI capability, but in the background it was actually like humans making it look like AI. So sort of honesty and transparency becomes important across all of those facets, and you should be aware of them. And then increasingly, deepfakes and digital replicas themselves are subject to targeted regulation across states. So, particularly in the political context, but also in generated content that depicts real individuals that are deepfakes, there's laws both at the state and federal level that are both passed and ongoing that are being targeted towards this space. And I'll just finally mention the other area that deepfakes are causing damage is security, right? There's been famous cases where basically deepfakes of CEOs have gotten employees to do harmful things. In Hong Kong, a firm lost $25.6 million after one of their workers authorized a wire transfer following a Zoom call with a deepfake of their CEO. So being aware of that and training your staff and your executives to be mindful for the damage that may come from this kind of vulnerability that's now enabled by AI is very important. So with that, I'm going to hand it off to Tony to talk about some of the practical steps and governance you can put in place to mitigate these risks.
Great. Thanks, Stas. So we covered, a lot of risk territory. So why don't we, end with some more on, practical points of what you can actually do about the risk. The goal is not to, scare you away from AI. The goal is really to, help you use it without stepping on mines. The good news, like most of this risk we've talked about is manageable, with a few things in place, including clear internal policy, the right contract provisions, a specific approach for AI generated code. So we'll talk about each of those. So let's start with AI policies and governance. So a written AI policy is sort of the foundation. We've helped many clients put these in place. And you'd also be surprised how many well-funded companies are deploying AI at scale without one. The policy doesn't need to be a 50-page document. It needs to be clear, practical, and short enough that, your engineers will actually read it. In our view, like a good policy covers the approved tools. So specify, which AI platforms are approved for which use cases. Draw a hard line between the enterprise tools we talked about before that include like data privacy commitments and the consumer tools, like the free tier of the tools where your inputs can be used for training. The list will need to be updated, so we plan for that. Usually we link in the policy outside to a list that can be maintained, outside the policy. Have some data input rules. Define what categories of data cannot be entered into the AI tools. Confidential information, personal data, client data, source code, financial projections. Be specific. Like I think, use good judgment is not a policy. It was at the very start of this, 2-3 years ago, but not now. Output review. So require human review of AI generated work before it's published, before it's filed, before it's relied upon in any consequential context. And, make this an actual workflow step, not just a guideline. Have a process for looking at new use cases. So, have a lightweight process for teams to flag, new AI use cases for review before they deploy them. And your team's got to be cross-functional. You want, legal advisors on there if you can get them, security review, and then just have sort of the relevant business folks for the request. And then it's really important to have like risk tiering. So not all AI use is equal. Drafting internal memos with AI, assuming we're using the enterprise system, is like low risk. Using AI to screen job applicants is high risk. So, apply proportionate controls. Low risk uses should have some sort of fast path for them. High risk uses, get a real review. And then you got to do like periodic refreshes. Like the AI tools evolve, every few months. Laws are being passed constantly. Build a review cycle in, minimum annually, but practically quarterly, or as the need arises from the new developments out there. And then the next area where you can put some mitigation in place is your contract provisions. So, every contract you sign or offer that touches AI should be reviewed through sort of an AI specific lens. Most standard form agreements, including many enterprise SaaS agreements that haven't been updated recently, don't adequately address AI. There's not many market terms for AI terms and contracts. It's all still pretty new, but I'll quickly run through the areas, we see come up over and over, some more frequently than others. And when you're the vendor, you should expect these things are the things the customers may ask about. And when you're the customer, these are the things you should be concerned about or thinking about. And also think about your other agreements, like employment agreements, contractor agreements, which should explicitly cover like AI generated work product. Standard IP assignment clauses often predate AI tools and they might have gaps. So kind of going through the common areas that we see get raised. The first area is like information. So what do I mean by that? Really sort of like disclosure of AI uses, including, both as to the capabilities, the specific technologies and the benefits, as well as actual or perceived risks, including areas such as security, privacy, the things that Stas talked about, discrimination, bias, IP infringement. So that's the information area. Control is another big area. So rights to approve or object to or otherwise influence how AI is used. Some of the requests we got early on were really clients contacting us to ask us if they had contractual rights to get the vendors to turn off the free AI functionality they were pushing into the products because they didn't want it. And they didn't have rights in most cases to do that. Another key area is IP ownership that we spoke about before, clarifications regarding who owns the inputs, who owns the outputs from the AI, at least between the parties. Sometimes a broad license to use and sub-license can be enough, and you don't need actual ownership. Another area Stas mentioned is training. So you want to address, training on the data. When you're the customer, require a contractual commitment that the vendor won't use your inputs, queries, or outputs, to train or improve their models without your, express consent. Many enterprise agreements offer this as like a negotiable option, but you have to know to ask for it. And then outside of training, data protection more generally. Additional restrictions on uses of customer data, even for aggregated and anonymized data for AI model training. Sometimes we see, restrictions on retention and use of like the customer's data to improve the vendor's services or training their models. We see extra security and data processing around, HIPAA type data. So we have data processing agreements, business associates agreements when they're needed, and different contractual security standards and audit rights is something that's got a lot more focus now with AI. And then good old-fashioned reps, warranties, covenants that you have in your agreements already, or you're going to have. They're kind of expanding. Like a lot of the existing language, covers AI, but there's a lot more, focus on compliance with laws, like the agentic AI case Stas mentioned. What does that mean for compliance with laws when there's an agent taking actions and it's not the parties? Having appropriate controls for like ethical and responsible conduct. Avoiding inappropriate, offensive or sort of harmful behaviors like discrimination, bias, undesirable results. Addressing security and privacy risks in your reps and warranties. It's likely now that you're not going to get away with on the vendor side of just providing the AI like as is, which you could do that, early on. But if customers are paying for it, they're probably going to want you to stand behind it. You're going to have some liability for infringement, by the outputs, by the model itself, by the training data, some transparency requests, around reps that you've taken steps to mitigate bias or you're complying with emerging laws. IP indemnification is probably the one you see the most. Like every agreement, addresses this or should. Does your vendor indemnify you if their AI outputs sort of create infringement claims, copyright or otherwise? Some of the big vendors like Microsoft and Google have formal, IP indemnification programs for their enterprise customers, but many other vendors don't. So, distinction matters when you're evaluating tools for commercial use, and then sort of think about the flip side of this when you're the vendor and what are your customers, gonna expect. Um, and then other kind of remedies and risk allocation. You're probably going to see things around sort of remediation or mitigation obligations. People wanting termination rights, refund rights, carve outs from the limitation of liability. Maybe some sort of quality requirements or disclaimers you want to put on the outputs of AI. I'll hit on agentic AI since we're doing okay on timing. It has some interesting challenges, and Stas alluded to a lot of this early on. If the tool's agentic, it can take autonomous actions like sending emails or executing transactions. You have to think about the boundaries in the contract. Like, what actions is the agent allowed to take? What systems can it access? What approvals are required for higher stakes actions? Make it clear, what the vendor's responsible for implementing for those restrictions, like in the contract and also, technically. And I think too, in your contract, like Steph's mentioning the autonomous actions, like allocate liability, make it clear who's liable when an agentic AI system acts, outside its intended scope or, causes harm through its autonomous decisions. The vendor contracts often disclaim liability for how you use the tool, but that's not going to protect you if the tool's design or default permissions are harmful. So you want to try to get specific as we can. And then if you're sort of deploying agentic AI to your customers, like add some specific terms governing what actions the AI can take on users' behalf. How users can revoke or limit that authority, and then have disclaimers on the AI's actions that might need human review. So have that require your customers to put human in the loop for certain types of things before they create legally binding obligations, and just like address the liability clearly. Like everybody's figuring this out sort of at the same time, and you got to factor in your leverage and things like that. And then the last area is just M&A, fundraising. So, AI reps and warranties are now standard in tech transactions. So if you're raising a round or you're planning your exit or IPO, be prepared to make reps regarding like training data provenance, where the data come from, regulatory compliance, open source obligations in the AI generated code. AI related litigation. Buyers are doing AI specific due diligence. Gaps in your IP chain of title and contract terms in respect to AI are all, deal level issues, that we're seeing. We have clients that have an entire, diligence stream just on AI now that they've kicked off, the same way they have one more generally on IP and on employment law and taxation. Like there's an AI due diligence stream because most software products have some AI functionality. And then I'm going to jump to the last kind of use case I have here for mitigations. And it's around like AI coding. So in my practice, this use case has sort of the highest interest. It's using generative AI for software development. So writing, testing, generally improving computer code. Over time in our work, sort of advising and creating the relevant policies for companies, we sort of divided this functionality into code generation and code augmentation. So code generation is really just creating new code or modifying existing code. And then code augmentation covers, creating, augmenting, or editing materials related to the code, like documentation, QA scripts, code comments, all the stuff that developers don't like to do. That's why this has been, a great use case for AI. So in our experience, the developers really want to use these tools. The developers understand generative AI, and they see this use case as sort of directly applicable to their work. And it's also pretty quantifiable. It's easy to run pilots to